call us to order, Chad.
Trying to pull something. Hey, this Commissioner Chilcutt to start this meeting for the Tennessee Athletic Commission board meeting, and hope everybody's having a good afternoon and ready to move forward with the agenda.
Thank you, sir.
Call to start as follows.
All right, we're going to go ahead and call roll then. Chad Chilcutt.
Here.
Donald Wynn. Steve Hanna. Steve Hanna.
Here.
Tracy Miller Davis. And Joe Smith.
Here.
All right, we have quorum. Gentlemen, let me go ahead and call the notice of meeting, and then we'll move on to the order of business. The notice of June 12, 2017 meeting of the Athletic Commission was posted to the website on June 7th, 2017. As with all of our other teleconferences, we'll need to read the statement of necessity before we begin. And then at the end of each matter which requires a vote, we'll have to do a roll call vote as well. And if you would, when we do the roll call vote, just state your name and then, of course, what your position is, yay or nay. All right, for the statement of necessity, according to TCA 844-108B2, if a physical quorum is not present at the location of a meeting of a governing body, the governing body must file such determination of necessity, including the recitation of the facts and circumstances on which it was based, with the Office of Secretary of State no later than 2 working days after the meeting. Furthermore, TCA 844-108A3 defines necessity as matters to be considered by the governing body at the meeting require timely action by the body. That physical presence by a quorum of the members is not practical within the period of time requiring action, and that participation by a quorum of the members by electronic or other means of communication is necessary. This is the regular scheduled meeting for the Tennessee Athletic Commission. The purpose of today's meeting, with some members attending by teleconference, is to discuss agenda as noticed on the website earlier. By one way of reminder, before we begin, we did have a hearing scheduled today, but since we didn't have a physical quorum, we did have to delay that or continue that until our next meeting. So if you gentlemen could mark your calendars for September the 26th, which is our next meeting date, we can go ahead and take that matter up as well.
So noted.
Great.
Got it.
I guess the first item on the agenda, first of all, is to approve the agenda. Did anyone have any amendments to the agenda or anything that they want to note or move around or that they wanted to add?
I'm good with it.
If someone would make a motion to approve the agenda, then we'll just vote on that to approve it as it is, and we'll move to the next item.
Chad, I approve. Chad Chilcutt.
Can we get a second?
Glenn, let me just say this, that I have one item that I'll bring up under new business.
Yes, sir.
Other than that, I second Chad's motion to approve the agenda.
That'll be fine. Got you down there. So Chad Chilcutt seconds. Chad Chilcutt, he makes a motion. Joe Smith seconds. Now let's take a vote. Chad Chilcutt.
Yes, I approve.
Steve Hanna.
Yes, I approve.
And Joe Smith. All right, the agenda is so approved. Now the minutes. Did anyone have any amendments on there or notice that they would like to, or anything that they'd like to change or bring to our attention? This would be the minutes from the last meeting, March minutes.
I move that we accept the minutes as presented.
Steve Hannell, second. Chad Chilcutt, third.
Okay, let's go ahead and do a roll call vote then. Chad Chilcutt.
Here.
Steve, do you approve, Chad?
I approve.
All right. Steve Hanna.
Yes, I approve.
Joe Smith.
Yes.
All right, the minutes are so accepted and approved. Now I'd like to go to the budget report. We do have some good news there to report. We were trending there for a period in the red. As you know, inspections are pretty costly, and but we were able to bring in some revenue based on a big venue recently with the UFC fight, and as a result, with the balance we're looking at, I'll just read you the last month of April, and then where our final balance is. Revenues, we brought in 86,000, and then the expenses, we're looking at 3,000 with a net surplus of 89,000. Now, how that shakes out for the year, we have for the fiscal year thus far, we have a yearly gross of 145,757. That's 145,767. That's revenues, and then we have expenses, total expenditures of 93,559. That leaves us with a net surplus of 52,198. Did anyone have any questions on that or any comments that they would like to make in regard to the budget report?
Senator Watson will be very proud of that report.
Yes, sir. We are pleased with that as well. Well, there not being any further comments, would anyone like to make a motion to accept the budget report?
So I motion to accept it. Chad Chilcott.
Joe, second.
All right, let's go ahead and take a vote to approve it then. Just an aye or a nay will do it, or approve or deny. It's Chad Chilcott.
Approve.
Steve Hanna.
Approve.
And Joe Smith.
Approve.
All right, it's so accepted. Now for the legal report.
Hello, this is Matthew Reddish, Board Attorney, Disciplinary Counsel for the Tennessee Athletic Commission. I'm going to go ahead and read through the legal report since everybody's appearing on the telephone. Don't know if you do or do not have this legal report in front of you, so I'm just going to go through entry by entry. Entry number 1, this was a complainant boxer alleged respondent judge improperly disqualified complainant for a punch to the back of the head of his opponent. Complainant alleges the punch landed to the side of the head and that his opponent was at fault for turning away from the punch in question. Accordingly, complainant requests that the bout be declared a no contest. Respondent referee states that he warned complainant once early in the fight about punches to the back of his opponent's head. In the opinion of respondent referee, complainant could have pulled the punch in question. Therefore, respondent referee stands by his disqualification of the complainant. My recommendation for this case is to close. Does anybody have any questions?
I move that we accept counsel's recommendation. Steve,
motion. Go ahead. Steve, second that. Chad Chilcott.
All right, what we can do is if we don't have any amendments when we get to the end, we'll just ask for one motion to approve the whole legal report. So just let's say, if you have no questions, just say no questions, and then I can move on. Entry number 2, complainants allege respondent fighter improperly kneed a fighter in the groin, ultimately leading to complainant's loss via submission. Accordingly, complainants request that the bout be declared a no contest. Respondent states that the knee in question landed to complainant's oblique and was never anywhere near the groin. Additionally, respondent points out that the submission did not occur until a full 2 minutes after the alleged low blow. There is no information to indicate respondent threw the knee with ill intent. The referee did not call a foul on the strike in question. Respondent and complainant has submitted conflicting images of the knee in question. However, it is unclear from either photograph whether there was contact with the groin ever made. Legal's recommendation is to close. Are there any questions?
No questions.
No questions.
There's no video on this. Is that what I'm hearing?
There is a video. It's just not particularly clear where the blow landed. And really, there's no indication as any kind of ill intent. Anything that did happen was incidental. The referee who was standing there didn't call a foul. And as the respondent pointed out, it is a full 2 minutes after this alleged blow that the submission occurred.
No further questions here. Thank you.
All right, thank you. Entry number 3. Complaint opened following staff receiving information indicating respondent held an amateur event without obtaining an event permit from the commission. Respondent admits to his error and states he believed the commission was not involved in amateur-only events and therefore didn't realize a permit was needed. Respondent provided evidence showing event did have proper approved sanctioning organization and insurance. Legal's recommendation is the authorization of a civil penalty in the amount of $250 for holding an amateur event without commission-issued permit. Are there any questions or comments?
No questions from Joe.
I don't have any questions. Chad Chilcutt.
All right, moving on to entry number 4. Complainant boxer alleges respondent judge improperly called the fight on a slip because the other boxer never touched the complainant. Respondent states he believed the complainant is referring to a stumble that occurred earlier in the fight. Respondent states complainant was taking hard shots and not effectively countering. Respondent states complainant was ruled a TKO after stopping the bout for a third knockdown in round 1. The stumble or slip was not what resulted in the TKO loss. Recommendation is to close.
No questions from Joe. None here.
All right.
No questions from Chad Chilcutt.
Entry number 5. Complainant manager alleges respondent judge failed to end a bout after the third knockdown, resulting in his boxer receiving a round 3 TKO victory rather than a round 1 TKO victory. Respondent admits he lost count of the downs during the contest and acknowledges that pursuant to the 3 knockdown rule in place at the fight, the contest should have been terminated earlier. Recommendation: amend boxer's record to reflect a TKO win in round 1 and overturn the current record of a TKO win in round 3.
I guess my only question would be, is the referee? I mean, I think we're walking on shaky ground when we try to overturn a judgment of a referee. So I'm okay with the recommendation as long as the referee is.
Absolutely agree. I think that's the distinguishing factor on this one is I believe the losing fighter was knocked down 5 times in the first round, and the referee admitted that he should have stopped the fight in the first round. I think is what's different from this one as compared to the earlier ones where the referee maintains that they either didn't see a foul or there's no ill intent on any foul or there have been warnings, things along those lines. This one, it appears our referee agrees that the fight should have been stopped in the first.
So he's human too. He can make a mistake, I guess.
It's ultimately your decision. If you think it sets a bad precedent, I certainly understand that, and I'm happy to entertain ideas to the contrary. It's not going to really change anybody's record because the person who would have won in the first still ultimately won. It'll just be changed to reflect what round he would have or should have won in.
Well, again, Joe here, I'm okay with it. I just want us to really be careful that we don't ever try to circumvent the judgment of a referee. But if the referee admits that maybe he made a mistake here, then I'm okay with counsel's recommendation.
Steve Hanna, I agree with Commissioner Smith.
Chad Chilcutt, I'm third on it.
All right. Well, since we have no changes to the legal report, we can have, if someone would like to make a motion to adopt the legal report in its entirety and second that, and then we can have a roll call vote.
Joe Smith, so moved.
Chad Chilcutt, I second the motion.
Okay, let me go ahead and take a roll call vote then. Chad Chilcutt.
I approve. I'm here.
Steve Hanna.
I approve.
And then Joe Smith.
Yes, sir, I approve.
All right, so moved. The legal report has been is accepted.
All right, the next item legal has to discuss is dealing with legislative proposals. We briefly discussed this at our last meeting. I wanted to see if anybody on the commission wanted to request. Basically, what I can do is we can submit a request to have statutes changed. The department can submit recommendations, and then it's up to administration whether or not those are taken up or not. So what I want to do is give everybody an opportunity. If there's something in our statutes that you think ought to be changed or modified in some way, we can discuss that now. You can make requests, and if the commission agrees and votes on it, I can submit those to our administration.
There's nothing that's been brought to my attention. This is Steve. That needs to be changed or addressed, so I don't have any comments or questions here.
Glenn, this is Joe. I'm going to have a recommendation surrounding the governance of amateur boxing, and I don't know whether now is the appropriate time to present that motion or to wait for new business. But it might change the statute. I'm not sure.
Well, if we get to the end of it and we decide we want to go about that statutorily, we can discuss that and make a legislative proposal at that time if you want, or we can do it now if you think it's a statute that needs to be changed to bring about the change that you want.
I really don't think it is, and I'll go ahead and introduce that now, and because it's really pretty straightforward and simple. In the past and 4 years, the state of Tennessee, the Athletic Commission, had nothing whatsoever to do with amateur boxing. And then during the time that we had Executive Director Mullen, in an effort to create a little stream of revenue, Mr. Mullen introduced a permitting process where someone that wanted to have a sanctioned amateur event, as long as they were following all the rules set up by the national governing body, the sanctioning authority, USA Boxing. If they were a nonprofit, there was no fee. But if they were not a nonprofit, there was a small fee. But everybody had to at least submit, a little one-page application, if you will. Somewhere along the line, probably after the old commission was sunsetted, I think the state, for whatever reason, decided to take a different position on that and insert themselves a little bit into amateur boxing. So I want to make the recommendation that we go back to the way it was, to where the state had absolutely nothing to do with amateur boxing. That is my motion.
All right, is there any discussion from either Mr. Hanna or Mr. Chilcutt?
Is there any notes, or does anyone recall why we got away from that?
I believe we weren't here at the time, but I believe Executive Director Mullen, they wanted to bring a little bit of extra revenue, and I think they wanted to start towards possibly regulating amateurs. And so they kind of brought about a little bit of a half in, half out. So we're going to issue the permit, and we want to require that amateur events have a sanctioning organization, and that the sanctioning organization have rules as strict or stricter than our own. And so we kind of brought this up last meeting, where we've kind of run into some issues where, for example, on the ambulance, our rules state that professionals have to have an ambulance. Therefore, under our statutes, it's kind of a communicative property here where sanctioning bodies for amateur boxers also would need to have an ambulance.
So my whole argument to that, Commissioner Hanna, is, these amateur boxing programs, many of them are run out of people's garages, and most of them are nonprofit. You don't make any money on these shows. You just provide an opportunity for young people to compete. And USA Boxing is the national governing body for amateur boxing in the United States, and is the sole sanctioning authority for amateur boxing in the United States. My pushback, and continues to be my pushback, was this ambulance requirement. For our USA events, the only time that we require an ambulance to be on site is for a national championship event. And when somebody has these local shows, a little smoker in Dixon, Tennessee, or wherever, some little small town, it becomes very cost prohibitive and usually some little gym owner, some volunteer is having to pay that out of his pocket. And so it's just creating a real hardship, and one that's just absolutely not necessary. We have a physician at ringside. USA Boxing requires that. So we have a physician at ringside, and I've been doing this for 25 years, and I just see no need whatsoever to pay $200+ to have an ambulance there as well. So that's my reasoning behind this recommendation. Plus, all of constituents, these little amateur boxing programs across our state are just really crying foul. There's no state in America besides us that requires that. So that's the purpose of my recommendation. I hope that answers at least some of your question, Commissioner Hanna.
It does, and I appreciate it, Mr. Smith. I'll second the motion from Commissioner Smith.
All right, so the motion is to submit a legislative request that the Athletic Commission no longer regulate amateur boxing in any way. And do we want to include mixed martial arts and kickboxing as well, or are we only wanting to consider this for boxing?
Well, my recommendation is for boxing because that's where I have the expertise. I would have to defer that question to one of my colleagues. They have the expertise in the amateur MMA.
Commissioner Chilcott here. The amateur MMA still runs into the same issues, and it's like we're needs to kind of line up, in my opinion. So it's the same because injuries happen in both, but there's obviously more contact in different positions in MMA, but you still have a physician there on site. Some of the amateur MMA shows I know struggle to make that money too, to put on different events. So it adds the cost in those.
And the governing body behind amateur MMA, don't we have 2 or 3 organizations that we rely on now for that?
It's mostly called UMAFA, UMMAFA, I think, or something like that.
There's another one, ISKA. And Waco.
Yeah.
Thank you, Aisha.
All right. Well, the motion is then to withdraw from the regulation of amateur boxing, unless somebody would like to make an amendment to that motion. If there's no amendment, then we can go ahead and do a roll call vote, and this will need to be unanimous since we only have all 3 of us. The quorum here is what we need to pass this resolution.
So as it stands, we've got Joe Smith making the original motion and Steve Hanna seconding that. Let me go ahead and do a roll call vote just to let me know if you approve or deny. Chad Chilcutt.
Chad Chilcutt, approve.
All right, Steve Hanna.
Approve.
And then Joe Smith.
Joe Smith, approve.
All right, it's unanimous then, so accepted.
Just so everybody's aware, what this means is that we're going to ask administration to put together a legislative packet to bring about these changes. This doesn't mean that these changes take effect today or are guaranteed to take effect at all. So I just want to make sure everybody's on the same page regarding that.
This is Joe. Yes, sir. I do understand that.
All right, thanks. Is there any other discussions? I know Commissioner Hanna didn't have any chads or anything you wanted to propose legislatively.
No, sir.
All right. The last item legal has on our agenda is deals with our administrative formal hearings. So currently, I would have to bring every complaint before the board in order to for us to pursue action against a licensee or an unlicensed person. Obviously, it's proving difficult. I think we've only had one physical quorum since the commission started. I think that was our very first one. And so what we can do is we can discuss the possibility of letting administrative law judges sit in your place for these hearings. So I can do the formal hearing before only an ALJ, and your presence isn't necessary. And then, I mean, we can find like an in-between ground. For example, if you want to hear all revocation hearings and everything else can go before an ALJ. I just wanted to get some ideas from you three regarding what hearings do you want in front of you, and which would you be okay with us going to an ALJ for?
Joe Smith here. You know, in all due respect, and I know that the attorneys are going to understand the law. I'm not so sure they're going to understand our sport. So I'm not so sure that I'm comfortable with giving a group of well-qualified attorneys that may not know our sport really well that kind of autonomy.
So is the question is whether or not we would be in attendance to these rule changes or legislation changes? Or
That's correct. For example, our hearing we had set today, we had a respondent who lied on his application in 3 different spots. He was under suspension from Kentucky indefinitely and didn't disclose that to us. As a result, we were trying to revoke his license so that he could no longer fight in the state of Tennessee. But due to our inability to get a physical quorum here present, his license continues to be active. So that kind of brings up some good example of some of the issues we have, as opposed to if we have administrative law judge alone, there's dozens and dozens of dates I could set that, and people wouldn't need to be present. What a lot of boards will do, because I understand Commissioner Smith's concerns, a lot of times they'll limit the judge to only something like unlicensed activity, which is pretty straightforward. Generally, the hearing comes down to did you have a license or not, is really the only question that we have to prove. Some of them are more complex. It's really your call regarding what you want to hear. But I mean, if you guys want to continue to hear everything, I would hope that we have more success getting at least 3 people here physically in the future.
yeah, I don't really have an issue with you facilitating that role. It's just, Matthew, it just would be, I mean, what would be the protocol for the heads up as to what you may be ruling on? Is this something that would occur after a meeting or a phone call with us, or how would that play out?
So, example, on the legal report, we had an entry where an individual held an amateur MMA event and didn't obtain the permit from us. And so you've approved me to settle that case for $250. In the event that individual refuses to settle it, I have to set that for a hearing. And so I'd have to come before you guys, and you'd all have to sit here, and I'd have to present the evidence that A, he wasn't licensed, and B, that he held an amateur event. And then he'd have his opportunity to cross-examine and go through a whole kind of a small little trial. And at the end of it, you would make the determination that, yes, he was unlicensed, and yes, he held this event. The way it would work differently now is that you still approve that penalty the same way. I still try to settle it. If they tell me no, then I just go before a judge without you present, and then I have to prove to the judge that he wasn't licensed. And then if for some reason that respondent disagrees with it, they can always appeal it to be heard before you. That doesn't happen very often, though. So you kind of have like a little bit of a first line decision making, because you do approve the legal report where I present those facts to you, and you can kind of make the determination whether or not you think what happened was a violation.
I got to hop off here, but I'll make my last comment is I don't personally have any issue whatsoever with you representing the board, so long as we've been given a chance to weigh in, which is what you just described. So if there's a way that we can do that, that would be my vote.
All right. Well,
I don't need to physically be present you're carrying out the wish of the of the board, so to speak, or the will of the board, if that makes sense.
Sure.
So we would, for example, in this case that we were going to hear today, you would hear that, and before the penalties or whatever consequences would be laid down, you would give us the opportunity to hear or speak to that before that happened.
Well, I think we've lost our quorum, so we won't be able to vote on anything going forward unless Mr. Wynn or Tracy Davis calls in. So we'll just have to kind of talk about things hypothetically from here out. We won't be able to make a decision on this today.
Yeah, okay, I understand. But is that correct? Is my understanding correct?
So the case in question was on a legal report maybe 6 months ago or 9 months ago. So that was presented to the commission. I presented all those facts, and the commission decided that revocation was an appropriate consequence for what he did. So that would be your initial opportunity. As I mentioned, you could make a decision kind of in the halfway point where you say, we want to hear all revocations and suspensions, but everything that we want to settle with a civil penalty, that can go before an ALJ because we don't find it as a serious. Or you could say, we only want you to go before an ALJ for unlicensed activity. Everything else we want to hear. There's any number of ways that this commission can decide what to hear and what not to hear.
Okay, I got you.
Maybe just think about it for next meeting.
Okay.
Because we did move the Lunsford case to next meeting, so and hopefully everybody will be here and you'll have an opportunity to see how that all works, because I think it's a new process for most people.
Well, you can always count on me to be there. I'm just on vacation this week.
I understand.
We understand. I believe since we've lost Mr. Hanna, unless Donald Wynn or Tracy Miller was to call in or dial in, as Mr. Reddish stated, we won't be able to vote. But we'll just quickly introduce some of these other items right quick and just discuss those. But again, we won't be able to vote unless they pipe in.
Maybe we could just take a brief break and we could try texting Donald Wynn and Tracy Davis. Is everybody okay with that? Maybe like a 5-minute.
Sure, I'm good with that.
Okay, that sounds great.
All right, hopefully we can get one of them on the phone then and reconvene the meeting.
Just going to briefly adjourn then. We're going to go ahead and reconvene where we left off, gentlemen. It looks like we have Chad Chilcutt, Joe Smith, and Donald Wynn. Is that correct?
That's correct, sir. Chad,
yes, sir.
Great. We're just going to go and pick up where we left off and just jump back in at new business. The first item on the agenda for new business is the ABC National Conference. The conference agenda and was posted online, but the schedule is July 22nd through July 26th, and it's in Mohegan Sun, Connecticut. And our Assistant Commissioner Carter Lawrence will be attending, and so will the Staff Attorney Matthew Reddish. We just need a motion to grant them the right and the access to go ahead and vote while they're at those meetings on our behalf. Do we have anyone that could make a motion to that end?
Motion.
Chad.
I just have a quick question. Who pays for that? Does that just come out of our fund?
I believe it does.
It does. That comes out of the general fund.
Okay. I'll second that motion.
I third the motion.
Okay. Okay, we're going to have to take a roll call vote, as is typical with anytime we teleconference. We have to take a roll call vote. So I've got the original motion with Donald Wynn, and then I've got the second with Joe Smith. Now let me go down the roll as presently constituted. Chad Chilcutt.
I approve.
Donald Wynn.
I approve.
And then Joe Smith.
Yes, sir, I approve.
All right, thank you, gentlemen. The next item is the 2018 proposed commission meeting dates. And we've got a meeting scheduled for each quarter. And if you had an opportunity, when we sent you those documents, did everyone get a chance to look at those? If not, let me just go ahead and read over them right quick. We've got March 12th, June 18th, September 10th, and December 17th. Now, those dates were selected based off the pattern of this year's dates as well. So it'll be a Monday at 2 o'clock. So nothing's changed as far as the pattern. But is there any conflicts there for anyone's schedule? Does that look like that'll work for next year?
That works for Joe? Yes.
That works for me too, Chad Chilcutt.
Okay. Do we?
Work with Donald Wynn.
Okay, great. Do we have a motion to accept the proposed commission meeting dates then?
Joe so moves.
Do we have a second?
I second it, Chad Chilcutt.
All right, let's go ahead and vote then. Chad Chilcutt?
Approve.
Donald Wynn?
Approve.
And Joe Smith?
Approve.
Thank you, gentlemen. The next item was the letter to USA Boxing. We kind of touched on that a little bit. We drafted a letter based on the discussion in the last meeting to be sent to the amateurs that would be under that sanctioning body, basically articulating what our expectations and requirements are. Now, we dived in a little bit about what the proposed legislative proposals for next year would be. But until that happens, we want to make sure that folks are under the requirement under the statute so constituted. Does anyone have any questions as to that letter?
No, sir. Chad Chilcutt.
No.
No, sir. Look good. Thank you for
Okay.
doing that.
Yes, sir. Our staff attorney put that together, and then once we gather together again in a physical quorum, then we'll have our chairperson, Mr. Hanna, sign that and send that out. Then
I can actually email it to Mr. Hanna and have him sign it, and then we can get that sent out pretty quickly.
Perfect. Can I have a motion then to accept that letter?
I second it, Chad Chilcutt.
So
Just a quick question. If we're going to approach having the statute changed, what's the timeline for getting that done? I mean, maybe the letter won't be necessary. That's the question.
So, new legislation will be proposed in January, and then usually our General Assembly, they wrap up all lawmaking somewhere around May 1st.
Okay.
So usually between May 1st and the end of May, they're done. I think they went closer to end of May this year because they had some more battles going on up there. And at that time, it depends on, we can try to have it become effective immediately, or we can try to, usually it'll become effective like January 1 of the following year. So we'd be looking at, sometimes it's like July 1, so it could be like July 1, 18. It could be January 1, 2019 are probably the two most likely outcomes.
Okay, so they don't even go into session until January, do they?
They do not. That's why we start this process now, so we can, if it's something administration wants to pick up, they can start talking to people and lobbying it well ahead of time to make sure, hopefully, it goes through smoothly.
Well, then you got to send the letter then.
That'd be my recommendation.
Okay. Have you got a second to that motion?
not yet. We have a original motion by Chad Chilcutt.
Okay, Joe will second that motion.
All right, gentlemen, let's go ahead and do a vote then. Chad Chilcutt,
I approve.
Donald Wynn,
I approve.
Joe Smith.
I approve.
Thank you, gentlemen. The proposed combatant medical form. There was some confusion at our last meeting because the form on page 10 or on the professional combatant physical examination form, it originally stated neurologist or neurosurgeon, a licensed neurologist or neurosurgeon must conduct the examination and complete this form. However, only a medical doctor is required, so we just want to state that into the form. So it'll say a licensed medical doctor must conduct this examination rather than the former neurologist, neurosurgeon. Did anyone have any questions or concerns regarding that?
No. Joe has no question.
Do we have a?
I don't. This is Chad Chilcott.
Thank you, sir. Do we have a motion then to accept it as articulated with it listed as medical doctor?
I'll motion it, Chad Chilcott, to approve it.
You have a second?
Joe Smith will second.
All right, we'll do a vote. Chad Chilcutt.
Approved.
Donald Wynn.
Approved.
Joe Smith.
Approved.
Thank you, gentlemen. The next item was the event permits. And we don't have an example of how we'd like to articulate, but we want to articulate the event just to kind of give it some sort of clarity as well, much like what we did with this combatant physical examination form. It's not certain about what time frame constitutes an event. For example, is that a 3-day? Does that constitute 3 days? Does it constitute, let's say, for example, I was doing a boxing event every Friday. Could I say that that's one event? I just so happen to do it every Friday. Or is it in fact a 24-hour period? And if you want to discuss that, but you would be free to do so, obviously. But we were thinking that to model some of the other industries, and like for example, ABC, when they do a liquor license, when they constitute an event to be a 24-hour period. So is that something that you would consider going forward, just to articulate that in our forms? Now, if we get rid of the amateur event, this would only apply to the professional boxer, but right now, both forms, the amateur and the professional, we just want to go ahead and clarify one way or the other what is an actual an event, what's the period of time that we have in mind.
I guess my question would be, so for example, if you have an event on Friday night and you have another event the following Friday night, you're saying that constitutes one event and only one physical is required? Is that what I'm hearing?
No, an event as intended, or what we would propose would be just a 24-hour period. So it would be one day. So if you had, that would be 2 events.
Well, I know that, and again, just speaking for amateur boxing, our athletes are required to have a physical on the day of the event.
So just for some background, the issue that came up is there was, I believe, a 3-day MMA amateur tournament that took place in East Tennessee, and they wanted to argue that it was all one event and they only needed one permit. And our interpretation of it was that, well, no, you would need 3 permits, because if your permit started, say, 4 o'clock p.m. on Friday, it expires Saturday at 4 o'clock p.m., and then you would need a second permit to carry on. And then I think what Glenn's talking about having every Friday night, that's like another example of something we could see where somebody would try to abuse the current language of our permit, where they just say that's just one continuous event. It just happens every Friday. So what we want is to make it clear that if you get an event permit, it is for only a 24-hour window. So if you start at 4 o'clock on Friday and you're trying to hold a fight at 5 o'clock on Saturday under that same permit, at that point you've gone into like an unlicensed type territory. If you're wanting to do that, you need 2 permits.
I got you. But just a point of clarification, is we run into this a lot, again, in amateur boxing, where we may have an elimination tournament. Maybe it's leading to a regional championship or a national championship that sometimes may take 2 or 3 days. Now, it may be different in MMA. Again, I'll have to, let one of my colleagues speak to that, but that happens a lot, where we'll have like a district tournament that leads to a regional tournament that leads to the national championships. and then sometimes those elimination tournaments may take 2 or 3 days, but generally speaking, they're back-to-back days. They're held on a weekend, for example. But they're required in that to have a physical every day. Even if they compete Friday night and they win, and they're going to compete again Saturday night, they got to have another physical. But in terms of what we have to pay USA Boxing for the sanction, if it's a sanctioned tournament like that, then it's one event. So I don't know if that has any relevance at all in what you're speaking to here, but I can see how it might could. Are y'all still there? Hello?
Did anyone else have any other comments?
Yeah.
Most MMA events are all over in one day, so I haven't heard of it going into another day or two. So the 24 hours is good on my part as far as what I'm talking about. But what Joe's saying, that's different for boxing.
Well, I think you just have to consider it from a regulatory standpoint. How do we determine? What if somebody wants to have a fight Friday night, rest Saturday, and then fight again Sunday? Is that different from every single day? I think we have to have some guidance from you. If you don't want it to be a 24-hour period, we have to have some guidance from you about when you consider an event ended.
Is there, again, so pardon my ignorance, but is there any way you could put language in there to say that an event permit is only good for 24 hours unless it's an advancing tournament? And that's just a question.
I think we could. I think the issue we have, for example, going back to the MMA, they had maybe 4 or 5 rounds of qualifying throughout the year, qualifying bouts. So then, they'd be able to come in and argue that our 5 events that we had, each one of those was leading up to this 3-day tournament, right? I think just trying to think outside the box. Obviously we're doing this off the cuff at this point, but that's what I'd kind of be concerned about, phrasing it like that.
Hey, Matt, Chad Chilcutt here. Could there be another amendment made for the ones that are going to do this type of tournament, and they would have to let us know instead of, and then it costs this X amount up front, that it's going to be longer than 24 hours.
I think that's kind of what we're getting at from our proposal to only have it be 24 hours. I don't think professionals don't seem to do this model at all. At least not since like UFC 1. I guess they had like elimination tournaments. But I don't think since then we've seen anything like that. I don't think we'd even sanction somebody to professionally box 2 days in a row. I think it only applies to amateur, and then at that point we're looking at a $50 permit is all they're paying. So even if they do have a 3-day tournament, it's a $150 expense. And ultimately, the promoter that we got into this discussion with, they were fine paying the $150 since it was really pretty minimal to put on a 3-day tournament. They were just kind of confused about the wording, and
Gotcha.
So that's why we wanted to bring it to you. And if it's something, I don't think it's something that's like urgent. If you want to table it and bring it back next time and just think about it, I think we could do that if maybe we don't have a consensus at this moment.
Yeah, I'm fine with it. It's $50 for amateur, and if and just as long as they know it's going to carry on to 2 or 3 days, and it's another $50 or that, it's basically a total amount of $150. I don't have a problem with it. I don't see it as a gigantic, huge cost, so I'm okay with it. We can come back to it next time for the other guys if you want.
Is there any other discussion?
I'm okay with this. There's no need to kick this can down the road, because if somebody's going to host a amateur boxing event, if they're a nonprofit, they're not going to be having to pay a fee anyway. So,
Yeah, that's a good point.
Yeah.
there's no need to kick this down the road, and it gives you guys the opportunity to get some clarity with what you're trying to get done. So let's don't kick this down the road. Let's go ahead and get done what you need to get done.
Yep.
So the motion would be that a event would be defined as a 24-hour period. Then, does anyone want to make that motion?
So Joe so moves.
Okay. So do we have a second?
I second it. Chad Chilcutt.
Let's go ahead and vote then. Chad Chilcutt,
Approved.
Donald Wynn,
Approved.
Joe Smith.
Approved.
Thank you, gentlemen. All right. The last item, unless we have something else pop up afterwards that you'd like to discuss, was Medlick update. I looked at these documents, and the Medlick initially were introduced to us by Alabama Athletic Commission, and at first, what my first concern when I was thinking about potentially bringing them on as a clearinghouse for our medical records, basically as a one clearinghouse where if it's a place where many different commissions are sharing this information, they could go to that one portal, almost like a patient portal. If you go to your doctor or something and they run labs, or they write their doctor notes, you can find that there in your patient portal, and it keeps those records for you. If you go back and you need those records, you can actually have them sent, if other folks share that portal, by request. You send either, you pick up the phone and ask someone to do that, or if you've already signed a waiver, they can do that, the administrative staff, on your behalf within that system. Well, it works the same way, except for with the combatants' medical records. They can send amongst the different commissions that are sharing a part of that portal. At first, what I didn't want to do was I wanted to avoid just adding processes, but if it was one of those situations where there was a benefit derived and we could add staff but not processes, thereby kind of burdening the system or even overburdening the licensees, then we want to avoid that. But they shared with us, the company shared with us their formatting. They shared with us their spreadsheets that they use, and they're very similar to what we already use with our promoters. And they said they can cater them to our needs and to our licensing here in the state as well. So once we realized that was the capability and that they would also serve as the call center, then that became a little bit more attractive in that regard when we're thinking in terms of adding staff to the licensing process for those licensees that would call in. Also, the other issue too was the interstate commerce piece. As you know, a lot of the promoters share these fighters from different states. So those records can be updated there immediately. We're not waiting on the fighters or waiting on other commissions to send that to us. We can just go, if you have access to the portal, and pull what you need. And of course, when you license a new person, you also upload that information in the system for others to view as well. Does that seem to make sense? Were you able to read some of the letters of recommendation as well, or did you have any questions in regards to Medlick?
Joe Smith here. To me, it sounds like a no-brainer. Just a couple of questions. I would just want to make sure that by sharing that information, we wouldn't be any violation of any kind of HIPAA laws, and I'm sure they must not be, or they wouldn't be doing business. So that would be a question. My second question is there any cost to us to participate with them?
I can answer the second question, and I'll defer to counsel on the first. The cost is $28 per year, which is basically payment for that call center that they're providing and for that portal. And they just the combatant would maintain their own file, and that at first we were that created some pause. But then we looked at some of the other industries, and you've got PSIs, like for example, Cosmo and Barber, when they're testing, they have to go to PSI to do so. So there's some of that we saw that were similar to other areas as well. NCES is another organization that's with our land surveyors, for example, where they have to do their testing there and then pay a fee to that vendor. So we realized there was a precedent there that as long as the cost wasn't too prohibitive, that it would be worth our consideration.
So the athlete, the licensed athlete himself pays that $28 per year fee?
It depends on the arrangements. I believe there's one commission where the promoter will do that, but ultimately it'd have to come from one of the two sources. Yes, sir.
So it doesn't come from us, I guess is the question.
That's correct. No, sir.
Okay, I got you.
And the good thing about it is if someone's a resident of Alabama and they pay for it in Alabama, they don't then have to pay it again when they come to Tennessee. No, they've already paid it once, and they're covered no matter what state they fight in.
Yeah. I think it's a no-brainer.
I approve it, too.
Well, we'll go ahead and take I guess the motion would be then to move forward on using them as a vendor. Of course, if we run into any sort of new information, then we'll of course make that available along the way. But it would be the intent of the commission then, from what I'm hearing, to move forward then as using them as a vendor to that end.
Joe Smith, so moves.
All right. Do we have a second?
Chad Chilcutt, I second it.
All right. We'll go ahead and take a vote then, gentlemen. Chad Chilcutt.
Approved.
Donald Wynn.
Approved.
Joe Smith.
Approved.
All right. Thank you, gentlemen. Now, Joe Smith, did you have anything else you want to add to the new business? I know you mentioned that earlier, but was that covered?
Yeah, I spoke to that. Earlier, and thank you for that. And let me ask you this, and maybe you'll have to get counsel to answer this. Am I allowed to talk to our legislators with regard to my motion surrounding amateur boxing, or is that out of bounds?
Let me do some research, and I will get back to you.
Okay.
All right, gentlemen, do we have any other business?
Joe has none except go fishing.
I hear you. Mr. Wynn, did you have any other business you would like to discuss?
I do not.
Mr. Chilcutt?
No, sir, I'm good.
All right. Would someone like to move that we adjourn?
Joe Smith, so moved.
Do we have a second?
Chad Chilcutt, I second it.
All right. We'll go ahead and take a roll call vote then. Chad Chilcutt?
Approved.
Donald Wynn?
Approved.
Joe Smith?
Approved.
Thank you, gentlemen. You have a great day. Thank you so much for calling in.
Okay. Afternoon. Bye-bye.
Everybody have a great afternoon.